Hi, my name is Mike Belgeri, and along with Nicola Chen, the president and founder of Celtic Wind Investment, we have several objectives to share with you in this presentation.
Explain how the IRS defines the tax's land trust beneficiaries.
Compare the difference between foreclosure defense and equity amelioration in light of the recent federal lender service fraud settlement.
Itemize the practical benefits of land trust conversion for homeowners.
A Florida land trust is an asset protection tool that was created by the Florida legislature in 1963 and brought to its current state in unanimous actions taken by the legislature in 2008.
A land trust is a document that converts real property into personal property. The personal property of the land trust is managed by an appointed trustee who serves at the pleasure of the property's beneficial interest holders. This presentation introduces you to the evolving history of land trusts in Florida from their origin in English common law to its best practice current usage in asset protection and equity amelioration.
To be properly configured for asset management, title forensic audits, RICO search, securitization auditing, and a well-educated, experienced land trust legal team must be involved. The information presented here is for informational purposes only and not intended for legal use without the consent or advice of a licensed attorney.
January 29, 1940. The United States Supreme Court held that state law creates legal interests and rights. The Federal Revenue Acts designate what interests or rights so created shall be taxed.
The law in any particular state may differ from a general rule discussed below, so it may sometimes be necessary to refer to the law in the particular state involved. There is no uniform or model law of trusts adopted by most states, although a few uniform laws relating to certain aspects of trusts have been widely.
Every express trust has one or more grantors who contribute the property to the trustee and state the terms of the trust. The trustee is the legal owner of the property but must use it for the benefit of the beneficiaries. As a fiduciary, he owes the beneficiaries duties of loyalty and care. The trustee may be an individual or organization. The beneficiary, also known as, get ready for it, cestui trust, is the beneficial or equitable owner of the property.
In February 2012, government authorities and 5 of the nation's biggest banks agreed to a $26 billion settlement that could provide relief to nearly 2 million current homeowners. The banks will receive financial incentives to distribute the aid over the next 12 months. The settlement announced February 9th, if you believe the $26 billion number, of which only $5 billion is actual cash. The settlement is 1/3 the size of HAMP, the $75 billion program announced in March 2009 as the administration's signature program to address problems in the housing market. But as the president pointed out nearly 2 years ago when he introduced the HAMP program, that's just not very much gravel to start rebuilding.
This settlement is, as Damon Silvers of the Congressional Oversight Panel, which monitored the bailouts, once put it, and I quote, "We can either have a rational resolution to the foreclosure crisis, or we can preserve the capital structure of the banks. We can't do both. Writing down debt that cannot be paid back, the approach Franklin Roosevelt took, is off the table, as it would jeopardize the equity keeping those banks afloat." Close quote.
Matt Stoller writes on Salon.com, open quote, "Moreover, when the banks have reached settlements with law enforcement officials, they generally don't hold to them. The Nevada Attorney General recently sued Bank of America for violating an agreement the state had made with Countrywide, once the largest mortgage originator in the country, now owned by BOA, to end various predatory practices. When you issue parking tickets instead of handcuffs for multi-billion-dollar crimes, the crime spree continues unabated." Close quote.
There are two ways a property owner can go. Well, maybe three. First, you can agree with a settlement and possibly get some small adjustment or minor cash settlement with a servicing lender. Second, if an owner has been served a lis pendens, he can get a lawyer and fight the legality of the case in court. That is, develop a foreclosure defense. Third, if you are aware that you have a mortgage that costs more than your property is worth, you can look into what we call equity amelioration by land trusts. We know what the first one will get you. Think of the settlement as being like one of the hens in the henhouse when the fox arrives. The goal of foreclosure defense is to protect the homeowner from the loss of the property. The goal of equity amelioration is to restore the equity of the home by using Florida's land trust law to its maximum advantage and removing the mortgage note's right to redemption by the lender through court action.
By the end of December 2011, according to Realty Track, 1 in every 500 U.S. homes had received a lis pendens notice from their mortgage servicer. Foreclosure defense begins after lis pendens filings at the courthouse. Homeowners under lis pendens letters get the help of a legal professional in many ways. This includes quiet title actions, wrongful foreclosure suits, stop foreclosures, stall foreclosure legal actions, court-based loan modifications, and out-of-court loan modifications. For those of you who are not lawyers, the legal dictionary defines a quiet title action as follows. A landowner may bring a quiet title action regardless of whether the respondent is asserting a present right to gain possession of the premises. Equity amelioration targets the improper lending practices that the banking system just settled with the government over. The banks are offering to settle for $26 billion. Sounds great. But it's with the individual state attorneys general. Think of it as a class action settlement of the largest crime in history, but it doesn't help any single property owner right now. Florida property owners can move their property into the protection of a land trust. This establishes a structure for those people who are keeping up with their mortgages but not building up their equity. The goal here is to get your equity in line with the value of your property and the payments that you are regularly making. The government settlement does not prevent individual homeowners and investors from pursuing the same recourse that the attorneys general pursued. But instead of winding up with a new mortgage from the bank that broke the law in the first place, the mortgage is voided by the court, and the land trust, your property, is no longer bound to the losses you have endured at the expense of bank misdeeds. That's equity amelioration.
Now let's run through some of the other benefits of moving property into a land trust. Unlike a corporation or limited liability company, there's no public record of beneficiaries. The title appears in the name of the trustee, and there are no requirements to register the trust in the county where the property is located.
Another valuable aspect of the land trust is the ease of investing with other people in properties. A pool of investors together can acquire, sell, or exchange properties that may otherwise be considered costly for one person. The selected property can be placed in a trust with each investor named as beneficiary and a percentage of valued interest assigned in the investment. In this type of scenario, a director can be appointed by the beneficiaries of the trust to communicate the wishes of the other beneficiaries to the trustee.
Many times, banks will approve short sales or foreclosure purchases, but prohibit the substitution of buyers on the subsequent transfer of the title for a time certain. A land trust may keep the same trustee, yet allow the beneficial interest to be sold without violating the bank approval.
Land trusts allow individuals with judgments or tax liens to buy and sell freely without having judgment liens attached to their property.
Rather than requiring multiple signatures, only the trustee is required to sign contracts and related paperwork.
Documentary stamps as well as title insurance may be avoided whenever there is a simultaneous closing.
Land trust agreements can provide buyout provisions in the event of death or conflict among property owners.
Unlike corporations or limited liability companies, land trusts do not have annual filing fees with the state. Additionally, they do not require a separate tax ID or an additional tax return to be filed.
Unlike owning property in one's individual name, contingent beneficiaries are listed in the trust document similar to the beneficiary designation on an insurance policy, thereby avoiding probate. If the property is in a land trust, the first major issue by probate is avoided. A Florida land trust can provide that property goes directly to the named beneficiary. This does not mean, however, that estate taxes or other claims of the probate are not settled, but it does give time in which the payments are made by the new owner of the trust. Land trust agreements can provide buyout provisions in the event of death or conflict among property owners. Land trusts avoid probate. They often serve as a will substitute. They can be amended at any time without having to change the deed. A Florida land trust owner can abrogate most of other states' ancillary administrative aggressions on the Florida property for the beneficiaries.
Land trusts, if desired, can be excellent estate planning tools to gift assets out of an estate to minimize or reduce estate tax without sacrificing or giving up cash.
Unlike a corporation or a foreign corporation, beneficial owners of a land trust, including foreign nationals, are only taxed on the favorable individual capital gain rate, which is presently 15%.
Previously, there was a debate of whether Florida land trusts would disqualify someone for a homestead exemption. Section 689.071 was recently amended to reflect that the principal residence of the beneficiary which is held in a land trust qualifies for the homestead exemption. We've documented the storied history of the Florida Land Trust in a digital workbook available for your review through our website. Just visit us at CelticWindInvestment.com and click on our contacts page. This has been a presentation of Celtic Wind Production.